Well, good morning, everyone, and thank you for joining us. My name is Michael Gault, and I'm an eminent domain attorney with Bell Carrington, Price, and Gregg. On behalf of Lindsay, Carrington, and myself, I'd like to welcome you to this virtual town hall regarding the North Carolina, a widening or a modernization of Highway 9 from 108 over to 74, just outside of Mill Spring, North Carolina. This project is not intended to add new lanes of traffic, but it will widen, add shoulders, and generally, as they say, modernize this section of Highway 9. I understand that this particular project has been a point of contention in the community, and so we wanted to reach out to let you know sort of what this process is and how we may be able to help. Let's just start with the general theory of eminent domain. As you can imagine, to complete a project like this, the DOT will need to take some property to increase their right of way on both sides of Highway 9 along this approximate 2.7 mile stretch. And in order to do so, they're going to reach out to the current landowners, those of you that own property adjacent to Highway 9, in order to attempt to obtain that property. Now, that doesn't always happen smoothly. And ultimately, even if the landowner is not in agreement, the DOT in this case will have the authority of what we call eminent domain to be able to take the property that they need to effectively build this project. And so that leads us to our first point. What is eminent domain? Well, eminent domain is essentially the legal theory that says that the government or a governmental entity can take private property for a public purpose. That's a long established principle, and there are a few ways to challenge that, but not many. But even though the government has that right of eminent domain, the landowners, you still have rights yourselves. Among the most important of those rights is the right to what we call just compensation, and that means that even though the government can take your property, they must fairly and adequately compensate you for what they're taking from you. Folks often ask, how does this process work? Well, with this particular project, we know that engineering is close to, if not complete, and we would expect right-of-way acquisition to start beginning in the next couple of months, sometime the summer of 2023, later this year. When that right-of-way acquisition kicks off, somebody from the DOT or a third-party representative on behalf of the DOT will reach out to you to let you know that you're impacted. They're going to tell you how they believe that you're impacted, and ultimately they will tell you what they think your impact is worth, what they're going to pay you for the property that they're attempting to take from you. That doesn't mean that you have to accept that offer. On the contrary, oftentimes landowners are in a position that they're unfamiliar with the process. They don't know the players, they don't know the terminology, they don't know how eminent domain works, and so they're intimidated or scared or worried about what might happen to their property. And they step up and they take the first offer. That doesn't necessarily need to be the case. And so that's sort of where we come in. At Bell Carrington, we have an eminent domain group. I'm the eminent domain practice group leader, and we have attorneys in states throughout the Southeast who represent landowners in eminent domain matters. And what we like to do is to meet with you one-on-one. In a forum like this, it's nearly impossible for me to be able to explain the impact, because the impact changes depending on which property we're talking about. But we like to hop on the phone or hop on a Zoom call or a virtual meeting with you to be able to discuss and to look at your individual property and how you may be impacted and what things the DOT may miss or may have missed if you've already been contacted in their appraisal and in their first offer to you. At Bell Carrington, we're fortunate enough to have some proprietary software that will allow me to pull up your property in real time while we're on the phone during that initial consultation. And I'll be able to see the impact to your property. This is not something that, we can dive into the multi-level details and look at cross sections and elevation changes, but I will be able to see within a matter of minutes generally how you're impacted. And so during that initial consultation, we can have an intelligent conversation about the impact to your property, some things that I see that you may want to be on the lookout for, and some things that I believe that our firm may be able to help you with. And so certainly while this, initial virtual meeting, virtual town hall is not meant to provide any legal advice, we invite you to reach out to us through phone or email. We have some folks standing by who are ready and prepared to speak with you today or at any time in the future that you find time and want to reach out to us just to talk about eminent domain, to talk about the project. And certainly if you're a property owner along this stretch of Highway 9, please reach out to us to find out, A, if you're impacted, and if so, B, how we may be able to help you going forward throughout this project. I'd like to touch on a couple of things real quick regarding those initial consultations. At Bell Carrington, our initial eminent domain consultations are always free of charge. It's no obligation. You don't have to sign up with us that day. You don't have to pay any retainer or any consultation fee out of pocket. We'd just like to discuss the project with you to see if there's a chance that we could move forward to help you. If there is, then the second thing I'd like to tell you is that at Bell Carrington, in our eminent domain practice group, we don't charge traditional attorney's fees. You'll never have to come out of pocket with a retainer. You'll never have to come out of pocket with attorney's fees. Instead, we operate on what's known as a contingency fee basis. And basically what that looks like is that our fee ends up being a percentage of the recovery, the settlement, or the verdict that we're able to recover for our clients in these particular cases. That looks different depending on the type of property and the case that we're dealing with and the landowner that we're dealing with. And so while I can't get into the details of that now, suffice it to say that you won't have to come out of pocket to hire a lawyer on a case like this. This is something that we operate on once the settlement or the verdict comes in a particular case. And I invite you, again, to reach out to me directly once we are able to establish what project you're on, what your particular property looks like. Then I can get into more details and explain to you exactly how that contingency fee basis works. So just to recap, the project, unfortunately for some of you, I know that this is not a popular project, is moving along. We would expect right-of-way acquisition to start in the next couple of months if you haven't been contacted already. Some of you are impacted more than others, but every property that's adjacent to Highway 9 along this about 2.7 mile stretch essentially is impacted. And it's important for you to have somebody on your side who knows the process, who knows the terminology, who knows how eminent domain works, to be able to help you from the beginning, to guide you through, to make sure that your rights are protected and that your property is protected in the long run. Again, Michael Gault, Lindsay Carrington with Bell Carrington. We appreciate you joining us this morning. Our contact information will be in the chat box or in the description. Feel free to reach out to one of us. We're happy to start the conversation with you and hopefully work with you moving forward. Thank you again.